Hello and welcome to this evening's Adam Smith Institute webinar. My name is Matthew Lesh and I'm the head of research at the ASI, and I do quite a lot of research work in the digital and online space. Thank you very much for joining it. We should hopefully have quite an interesting discussion. We're streaming live to Facebook as well as with the people in the webinar. Please feel free to add your questions to the Q&A chat, which will be coming to after some introductory remarks from our guests. Before we get to that though, I'm going to give some brief remarks myself, setting the scene. So I really think we can think about the transformation of debate about the online space over the last decade as quite an extraordinary shift. In the early 2010s, we had a sense of unmistakable excitement about the power of online platforms to connect people and to upset totalitarian powers, particularly around the Arab Spring. In recent years, however, this optimism has been replaced by despair. Digital companies have become enemy number one for society's ills, from concerns about online censorship to the proliferation of truly problematic material like terrorist and child abuse material, to the evils of polarization, mental health issues, and even big tech monopolies, and many more. Now, after many years of discussions in the UK, a green paper, a white paper, two responses, we have a draft online safety bill, which will be the focus of our discussion this evening. This bill has been promised to make the UK the safest place in the world to browse the internet. It will attempt to tackle a wide array of issues, from child abuse and terrorism to racist abuse, disinformation, scams, and much more. The bill creates a so-called duty of care on social media sites and search engines to safeguard users. There'll be duties related to preventing unlawful material, protecting children, and even adults from material that is, and I quote, legal but still harmful. Not to be outdone by all these lofty goals, the government has now also more recently added requirements to mandate digital companies protect freedom of expression, exempt journalistic content, and putting special protections for, I quote, democratically important content. This model raises many questions. Will the mandates, particularly around legal but harmful content, create pressure to censor online speech? What does the risk of mission create when it comes to freedom of speech, considering the powers of Ofcom and the Secretary of State to set online harms, as well as Ofcom to create guidance and codes of conduct, I should say, for how the companies fulfill their duties of care? Why is it necessary to exempt journalistic content if the bill does not threaten freedom of expression? Does the law create an effective mandate for age verification by requiring child-friendly sites, the child-friendly only content by default, and therefore age verification meaning entering your passport or driver's license or credit card to view the adult version of websites that are not just child-friendly? How will this impact startups and scale-ups? What's the kind of regulatory requirements that are being put on by this bill, particularly with the government's estimate of a 2.1 billion cost of legislation, including an extraordinary 1.7 billion to be spent on content moderation? And then finally, but perhaps definitely not least, will this actually have much impact on criminal behavior online? To answer these questions and many more, we have a fantastic panel of speakers. We have Victoria Hewson, the Institute of Economic Affairs, Graham Smith, who's a leading internet lawyer, as well as Ruth Smith, who's the CEO of Index on Censorship. Victoria, if you don't mind, I'm going to bring you in first to this discussion. Now, Victoria is the head of regulatory affairs and a research associate at the Institute of Economic Affairs, and is the author of the IA's recent paper, More Harm Than Good, The Perils of Regulating Content. Victoria, how is the online safety bill going to change the way speech is dealt with online?
Thanks, Matthew. So I think really the impact of this bill can't be overstated. For a start, just thinking about the scope of it, it covers all user-to-user services that allow users to share and add content. And it covers search as well. And it covers all of these services, so-called regulated services, with a few exemptions that we might come to later, that have that operate anywhere in the world, but have, quote, links to the UK. Now, the links could be based on their number of users in the UK, whether they're actively targeting the UK, or whether there's just a material risk of harm, in quotes, to individuals in the UK. So of necessity, this bill would have extraterritorial effect on any platform potentially in the world. So we can already see that it's a pretty ambitious proposition. Now, in terms of the core duties that Matthew's just alluded to, the core duties are these so-called duties of care, which will apply to all regulated services. And it's sort of, you can, I guess, split them into two. There's risk assessment duties, and then the actual operational safety duties themselves, which are expressed in quite sort of technocratic language around using proportionate systems and processes designed to minimize the presence and availability of the different forms of content that the government wants to be removed or deprioritized, or simply filtered. And there's a difference here between generally all services that have these basic duties around specifically illegal content or priority illegal content, which is one of many as yet to be defined phrases. And then category 1 services, which is the largest user-to-user sharing platforms, again, not yet defined what that category threshold will be, who will have additional duties to counter harm to adults. That's harm that may well be perfectly lawful content, but that will be considered to be harmful. I should add as well, all platforms in all categories will have additional children's risk assessment and safety duties too. So that's, we can see that that's pretty ambitious stuff. And let's be very clear, when we talk about risk assessment and then using proportionate systems and processes to minimize presence, what we're talking about is filtering and removing content basically at source. And inevitably, this will, of course, mean using automated tools to do so. Couple of quick points about some of the content that is in scope and how that's defined. Regulated content specifically doesn't include emails and SMSs, which is good. It doesn't include comments and reviews on sort of official provider content or paid for advertisements. And it doesn't include this new concept of news publisher content, which almost feels a little bit like a backdoor way of regulating the press, because in order to be a recognized news publisher, to benefit from this really quite useful, beneficial exemption from having your content regulated in this way, you have to meet certain regulatory standards. Now, the standards themselves are not very strict, and most sort of web operations, if you like, will be able to meet them, but it does very much mean an end to anonymity, potentially, for anyone who wants to have this benefit. One of the requirements is that you have to be, or rather you can't be anonymous, and you have to have a complaints program and sign up to be regulated, albeit internal codes of practice will count. So that's obviously great for traditional legacy press and broadcasters who've been pushing very hard for this regulation and have managed to get themselves this rather important carve out. Very briefly on the definition of harm, this is something else that is still really to be scoped out in regulations, which will define specific kinds of harm and priority and primary priority harms that will attract more intensive duties. And I think that's where the romance fraud and other scams will come in, because they're not currently, I don't think, as far as I have found, they're not currently directly tackled here. But there is a catch-all definition of harmful content, which is broadly linked to or based on significant adverse physical or psychological impacts, either on children or adults. Now, this is all quite heavy stuff. To mitigate it all, or as the government rather confidently asserts, to remove any risk of over-compliance and over-removal of content that's actually perfectly legitimate and not harmful. The duties also include protection of freedom of expression and privacy, which all regulated service providers have to have regard to when they are carrying out their duties. Now, there's a lot riding on these duties. As I say, the government thinks that they will guarantee freedom of expression. I would note, though, the use of the word unwarranted infringements on privacy seems to accept that there will be some infringements of privacy, but presumably only warranted ones. Matthew also alluded, we've got specific protections for category 1 service providers who also have to pay regard to content of democratic importance, which is pretty narrowly defined as being rather narrowly political and party political, and journalistic content also gets some special treatment. Now, disinformation and misinformation, again, is not currently there in the definitions of harm, but I won't be surprised if that is included in the eventual definitions that come by way of regulations. And there is an advisory committee that Ofcom will be obliged to constitute to sort of advise platforms on what they will be expected to do about disinformation and misinformation, which is rather worrying. Now, I've mentioned Ofcom there. The way this legislation will work, as in many cases, the actual primary legislation sets out some quite high-level obligations and duties and some definitions, but a lot of this is to be filled out both by regulations, adding more defined terms, and also in this case, most materially, by way of Ofcom, the designated regulator, producing codes of practice to set out recommended steps for service providers to take. Now, if they take these recommended steps and follow the codes of practice, that will basically guarantee their compliance. Now, it's possible for a firm to take its own legal advice and decide, no, we don't need to do that. We can comply with these legal duties by doing things slightly differently. But that's a big risk. The easiest way to do it is going to be to follow what Ofcom says, which gives them immense power here. And I would just highlight one final point, because I'm probably running over my time, is that the Ofcom codes of practice will include recommended steps for service providers to comply with their freedom of expression and privacy duties. So Ofcom will not only be in a position to tell the service providers what they have to censor and filter and remove, but also how they can go about that in a way that supposedly safeguards freedom of expression. So I think there's going to be some difficulties there. And it was disappointing, actually, that all of the supposed safeguards seemed to be adding duties onto the service providers and very little constraining what Ofcom is going to be able to do here beyond a bit of consultation, and obviously directions that can be given by the Secretary of State from time to time. The concern there, of course, is that politically the Secretary of State will be urging them to be ever more restrictive and perhaps less respectful of freedom of expression. So I will stop there and look forward to picking up more in the questions.
Well, thank you very much, Victoria. Just before we move on quickly, I think there's a lot for our audience to get their heads around, particularly if they're new to this space. I think kind of a key takeaway from what you're saying is effectively Ofcom will have the power through these codes of conduct to require what kind of content social media sites must host, and then what kind of content social media sites must censor by kind of expanding what is defined within the duties within the system. I'm kind of interested, just a kind of a quick thought about the kind of inherent kind of contradiction in the bill between this idea of we're trying to protect people at the same time as protecting freedom of expression. It seems like they're trying to do everything at the same time. And when there's a conflict potentially between those different duties on companies, I'm interested in how you think that'll eventuate in practice. On the one hand, Ofcom says, well, you have to, deal with such and such hate speech content in this way. It might be legal speech, but we think it's harmful enough and psychologically difficult enough that you have to deal with this in a serious way. What are the companies meant to do if they've also got a duty to protect freedom of expression?
Yeah, it's to me, on the face of it, this looks pretty intractable, and it's actually very much in line with what Daphne Keller, the academic, I think, at Stanford, who used to work in this field for Google, I think, wrote about this idea of different regulatory approaches. Could be you can have a must carry obligation, and that will potentially suit people who are worried about platforms being biased, especially against potentially conservative voices, for example, and they want a must carry to prevent unfair suspensions of particular people. But then you also have a must remove obligation to satisfy people who are worried that there is harmful or unlawful or offensive content on there. And the bill has clearly tried to achieve both of those things. It feels a little bit like the freedom of expression and privacy protections don't fit terribly well with the way the rest of the bill is drafted, and might have been
a little bit later, would you suspect, in the drafting process,
to try and assuage the concerns of people like us. So yeah, I mean, it seems pretty intractable. I don't envy the job of the Ofcom drafter who's going to have to try and put all this together. But on the other hand, Ofcom is given immense powers here. And obviously they will remain subject to the general public law duties to respect the Human Rights Act and all of that. But I would have, as I said, I would have probably quite liked to see that spelled out a bit more explicitly.
Look, let's bring in Graham Smith. Graham's a leading internet and IT lawyer. He's co-author of the Internet Law and Regulation textbook, which is now on its 5th edition, was first published in 1996, which means he's been publishing books on internet law and regulation for almost practically my entire life. So I was hoping Graham could give us a bit of context in terms of what he thinks is new and interesting and different about this, and how it's situated in kind of the history of our approach to the internet law and regulation.
Thanks, Matt. I'm delighted to do that, and thank you for the invitation to participate. Before that, just before I embark on the history, I think just one other comment on the contradiction between these duties is that the freedom of expression and privacy duties are very much more weakly expressed in the draft bill than the safety duties. The safety duties are expressed as a duty to put systems in place that will achieve certain outcomes. The privacy and freedom of expression duties, freedom of expression in particular, are expressed as have regard to the importance of. And one can see that if there's a clash between an absolute duty and a have regard duty, I think the people are going to jump in the direction of trying to comply with the safety duty because it's more strongly expressed than the have regard freedom of expression duty. So a little roundup of the history. I'm going to go back actually quite a lot further than 2010. Back to the dawn of the web, not the dawn of the internet. The internet had been around for a while, but if we look at the dawn of the web back in around about the mid-90s, I think with this draft bill and with similar initiatives around the world, we've pretty much come back full circle to some of the ideas about how to regulate the internet that were discussed and, at least in Europe and the US, pretty decisively rejected 20 to 25 years ago. And I think to understand this, we have to think about two parallel themes here. One is liability and the other is responsibility. And by liability, we mean, should the platforms, the hosts, or other intermediaries for that matter, be made liable, there will be a risk of liability for when users using their services do things that are unlawful or illegal. So that's the liability aspect of it. The responsibility aspect is, should the platforms and so on be placed under proactive, positive obligations to take steps to control what their users do, to block what their users do, typically sort of monitoring, moderation kind of obligations. And these sort of sit side by side, but they are a bit different. And it's I think what we're seeing now, of course, is the huge resurgence of the responsibility aspect of things, whilst the liability side of it under the draft bill is pretty much remaining untouched. And the other theme that I think we can take from the early days was there was a rejection of the idea that a broadcast model, that discretionary regulation by a regulator was the right way to govern individual speech. The model, the broadcast model, at least in the UK and Europe, was quite decisively rejected. Some countries did go down that route. Australia and Singapore, for instance, imposed broadcast type regulation models on the internet, but on the whole, that was rejected. And why? Because when we're talking about these regulatory provisions, regulatory models, they tend to be framed in terms of regulating the platforms, regulating big tech, if you like, but in reality it's regulating you and me. It's regulating how you regulate what you and I can say when we're using these platforms. And traditionally, both offline, definitely offline and online, the settled model has always been that you don't put a discretionary Lord Chamberlain of the internet in charge of deciding what individuals can say. You pass general laws and you enforce general laws. And there's quite a conceptual difference there. What is similar, going back to the mid-90s, is that immediately before the web, we had a collection of monolithic platforms, the CompuServes, the Prodigies, the AOLs of this world, who were running discussion forums. And then the web came along and knocked them out of place, and it became distributed. And we had discussions then about, on the liability side, what sort of liability should attach to platforms. And the model that was mostly thought appropriate was that platforms should be regarded as akin to distributors of the content of their users. And so in the UK, we had the 1996 Defamation Act, which applied to a bookshop type model to platforms, said you're only liable once you have knowledge of something illegal going on. You're not liable in the sense of a newspaper publishing its own content. And from a regulatory point of view, if you look at something like the Communications Decency Act case in 1996, ACLU and Reno in America, we were equating internet users to town criers and pamphleteers, and we rejoiced in the chaos and cacophony of the internet. And that case again rejected the idea that the internet is TV, and rejected the idea that broadcast type regulation was appropriate. On the responsibility side, there's very much the feeling that intermediaries should not be compelled to monitor their users or to control them. Not because, partly because this would be a burden on the platforms, but mostly because of the desire to retain the ability of users to speak and to enable the free flow of information. And when we look at the e-commerce directive, which came in at the end of that decade, we see again a sort of bookshop type liability model for hosts and platforms. And we also see something called Article 15 of that directive, which anticipated that governments might see some kinds of internet intermediary as choke points and seek to weaponize them to block particular kinds of information, and said, well, this is not a good thing, and it prohibited EU member states from imposing general monitoring obligations on platforms. So you had this twin track in the e-commerce directive of liability protections on the one hand, and banning of imposing monitoring obligations on the intermediaries. We then go into the 2000s. We not a huge amount happened to begin with. We had the Communications Act 2003 in the UK, and there was discussion then about whether the internet should be regulated by Ofcom. Ofcom was created by the 2003 Act, and the decision was quite deliberately to exclude the internet from Ofcom regulation. Whether it was a couldn't or shouldn't is perhaps debatable, but there was certainly a strand that said no, discretionary regulation has no place in how you should govern the speech of individual internet users. We also had in the EU, the Sabam and Scarlet and Netlog cases in 2011, which held that it was would be against both Article 15 of the E-Commerce Directive and the EU Charter of Fundamental Rights to impose filtering obligations on an ISP. There was at this time pressure to change the ECD, the E-Commerce Directive liability provisions, which was resisted. And I think it's fair to say an increasing recognition of the role of fundamental rights and the effect on users' privacy and freedom of expression. Moving forward into the 2010 onwards, we had the first, well, I think one could say the first departure from the bookshop model. The EU in the Google France and L'Oreal and eBay cases said, well, if you want to have the advantage of the hosting exemption from liability, then you have to keep hands off from the content. You have to act in an agnostic, neutral kind of way. And this, I say this is a departure from the bookshop model. If you think of a bookshop, they are not deprived of their liability exemptions, because they are a left-wing bookshop and only stock left-wing books, or because they put particular books in their window and select them in that way, or whatever. So this was quite a departure from the bookstop model. And you also had a series of cases in which the court started to issue site blocking injunctions against ISPs. And so we're seeing resistance to making use of internet architecture for content blocking purposes and the like starting to be overcome. Then I think from probably 2015 or abouts onwards, we've seen the tech lash, and I don't need to really describe that to you. We're all with it. We have the concerns about terrorism, about misinformation, disinformation, effect on children, vulnerable adults, and in parallel, a sort of growing belief that if the tech companies would only nerd hard enough, then all these problems with the internet could be solved. And we also, I think, have now the full emergence of the sort of trust and safety themes that are now driving policy. I mean, those did exist way back in the early days. The Internet Watch Foundation was started in around about 1996. It was a voluntary initiative. Rather familiarly, it was done under the threat of regulation, perhaps an indication of the kind of dialogue that was to come. And of course, we've had the re-emergence of, if you like, pre-internet style large platforms presenting themselves, not deliberately, but they're there as a regulatory choke point once again, which perhaps wasn't so obvious for the last 15 years or so. And we have the full re-emergence now of discretionary regulation, broadcast style, as a model, with a body like Ofcom being put in charge of the online safety bill. And we have the emergence of the imposition of responsibilities, general duties and obligations, and with the online safety bill, really the first explicit departure by the UK from the ban on imposing general monitoring obligations. The core obligations are quite clearly intended to produce proactive monitoring, filtering type obligations. So I think the result is that we are doing something with online speech that we would never have dreamed of doing with offline. We're subjecting it individual speech, not to, well, it is, of course, subject to the general law and lots of it. as Matt alluded to, the general law does apply online as it does offline. It's almost impossible to think of a law that doesn't apply online as much as it does offline. And we're subjecting individual speech to the decisions of, or indirectly through the proxy of the platforms, to the decisions of a discretionary regulator. That's something we would never have dreamed of doing offline. Yet, in this weird and wonderful world of the internet, we think that this is what we should do online. That's it. Thank you, Matt.
Well, thank you very much for that roller coaster ride in a very few minutes through something that you've spent an inordinate, crazy amount of words describing. I just want to bring in Ruth, and then we'll come back to Graham and Victoria with some more questions. We've got some great questions coming through in the Q&A. So Ruth Smith is the CEO of Index on Censorship and the former Labour MP for Stoke-on-Trent North. Ruth, I wonder if you can update us on where we're currently at with this legislation, and what the kind of the politics of this is going to be over the next few months. I know that this is a draft online safety bill according to the government. And I'm wondering if you could tell us what that means to say that it is a draft bill.
Absolutely, and thank you, Matthew. It's I'm going to aspire to be a politician and speak briefly as possible so that people can get their responses to the Q&A. So just in terms of the practicalities of where we're at, this is a draft piece of legislation, and the government have decided to do something that they hadn't done in my 5 years in Parliament, which is pre-legislative scrutiny, which is likely to start this summer, and bringing together from both houses a committee to explore the legislation. And given the nature and scope of it, I think that's incredibly sensible, because there's so many different issues, as Graham and Victoria have outlined. There's just a couple of areas, again, that I'd like to touch on where I have significant concerns about the legislation, starting from the premise that there is a problem online. And I think unless we acknowledge that there is an issue about the culture online, then we haven't really got a voice in this debate either. And for those of you who know me or know of me, you'll know that I personally have had significant experience of how toxic it can get online. The question is fundamentally, though, whether this legislation is going to do anything to fix that or to help. So I just want to touch on 3 areas which Victoria mainly touched on. The first is the concept of legal but harmful, and what that is. It is absurd to me that we would be creating a new format of speech that would be regulated in terms of what I wrote down online, but not what I would say down the pub, or what I would put on in an op-ed for a national newspaper. It is absurd in the current world that we live in that we are going to categorise speech as it's legal, but it's now unlawful. The second is, and I find this, and obviously everyone knows my personal politics, but I find this bizarre from a Conservative administration, that this is about, that the onus of this legislation is not on the perpetrators of hate, not on those people we know to be breaking the law and making children vulnerable, but rather is on the platform. So there is no element of personal responsibility that comes through this draft legislation. And that seems completely bizarre to me. And the third issue, which I think is key, and Victoria detailed, was about content being removed. There is no legal framework outlined in the legislation or that currently exists in a British or even European context that will allow us to see what's been removed. No platform wants to retain information or retain data that is perceived to be illegal. So I, as a victim of hate crime, that content would be automatically deleted permanently. So how would the police and security services be able to access it? How would we know what had been deleted? And importantly, for I, as a victim, how would I know if I was vulnerable? And how would we ensure that people could be prosecuted for what they've done online? We already have a significant issue with the Malicious Communications Act. As a little anecdote, because, why wouldn't I talk about my death threats? I got 2 death threats during the 2019 general election. One was physically hand-delivered to my office. The other one was online. The person that gave me a death threat kindly hand-delivered it. They've gone through the criminal justice system. I heard 2 weeks ago from CPS that they are finally prosecuting the person that threatened me online. It's taken that long because the police haven't got the resources to engage with this, and malicious communication becomes really difficult online. We should be strengthening the powers for dealing with these issues, ensuring that the police and security services have what they need and that they've got the resources to work within the current legal framework, rather than introduce something that is going to create mass confusion about what is legal, what is not legal, what's unlawful versus what's legal, and delete content. And one of the final points before I get in trouble with Adam, with Matthew for talking too long, but for the first time, there is evidence that was collected by social media companies for war crime prosecutions. I've been doing some work with the Syrian War Archive mnemonic, who collect social media evidence about what happened in Syria. A third of what they've collected has already been deleted by the platforms. We would never be able to see that again. So one of the issues we've got here is how we hold and collect evidence. And it isn't just about people like me or you, it's also about how we will ensure that there is a proper legal framework in place for things like war crimes, which is extraordinary. So I'm going to leave it there, Matthew. I hope that's what you were looking for, and open to Q&A.
That's excellent. Thank you very much, Ruth. And I think there's some fascinating current cases going before international criminal tribunals using evidence from online spaces that the Online Safety Bill would effectively mandate are removed immediately, effectively censored straight away from the platforms before they are stored or catalogued or known about. And I think that goes back to that fundamental kind of principle question, which is, we know people do bad things and people are abusive and harass, and I don't think anyone would doubt that there is problematic behavior that goes on online as a part of an extension of the fact that there's problematic behavior offline. If we're living a lot of our lives online like we have over the last year, you're going to see that behavior magnified. You're going to see records of it online. The question I kind of have is, to what extent do we want to be able to see that material? Is it a moral good in a way to be able to see people say wrong, abusive, disgusting things and be able to hold them to account for things they say in a classic J.S. Millian way, rather than assuming that, and this is kind of a good question put by my boss, Eamon Butler, that we need to protect people from kind of psychological harm. And then it goes to the question of how you then measure psychological harm. So I was wondering, from kind of a free speech perspective, whether or not you think there'd be more value in highlighting bad behavior rather than in trying to define psychological harm and then removing that material accordingly.
So I think there's two elements of this. First of all, one thing I should have said is what we really need is a digital evidence locker that all content that's being removed is going into, so that academics, civil society, law enforcement, and journalists can access to see what's being removed. I think that'd be an incredibly important part of this. But in terms of how we protect people, I would come at this from, we need to know what people are saying, so that both in terms of misinformation, in terms of racism, so that we can make the counter argument, so that we can have the proper debate. Otherwise, we don't know how to do that. And it would be perverse, especially for a Conservative government, to want to remove this kind of data. But we have to be brave enough then to have the argument. And I think that that's where we need to be on this. At the same time, not everything needs to stay up. I mean, when something goes from legal but harmful and doing psychological damage, but steps into inciting violence or very clearly restricted speech in terms of hate or extremism, of course that should be removed. But there is lots of space in between. The other issue I have that I think that relates to this and would be concern for everybody is that speech and language evolve constantly. And if suddenly we're going to have keywords and we'll end up having to have keywords, because the algorithms will go and find those keywords. Otherwise, how will you implement this legislation? that language will evolve and move on, and we'll have dog whistle language, and we'll have, it will all become code. And so unless you've got computers that are going to be able to analyze context, and they're good, but they're not that good yet, then I think that we'll lose, the wrong language will be removed. And there was a politician who suggested that the word rape should be removed from every comment on a platform, from the view that no one should be talking about rape. But if you're a victim of rape, you're more likely to use the word rape than someone who's likely to go and perpetrate a rape, I'd suggest. So you're taking away people's options to articulate their own experiences, to talk about their lived experience. And one of the things that is really difficult, and look, none of this is straightforward, it is really, really difficult area, but we need to have a national conversation about where the line should be. If you've been self-harming, and we should be candid that during lockdown, lots of people have struggled. If you were self-harming and you were using social media platforms as a mechanism for your own treatment, as a way, because you can't go to group therapy, you can't engage in that way, but you were talking about what you've done to yourself with other people who have also struggled, that would automatically be deleted. So because it would potentially, you could be considered of encouraging people to follow in your footsteps. Where does it leave those people who are already really struggling? So in terms of personal responsibility, but also people's lived experiences, this doesn't help anybody, in my opinion.
Yeah, I think this is this really difficult question in terms of online speech, that some of the wealthiest and most technologically advanced companies in human history are really struggling to determine what is against their policies at the moment, let alone unlawful. And they really struggle to distinguish between what is sarcasm, what is serious, what is promoting, and what is discussion about. And creating all these kind of duties, I think the impetus will be on the removal of speech, on the basis that you want to avoid because if they fail to fulfill their duty, they're looking at potentially multi-billion pound fines and a huge kind of burden on the companies. So it creates this kind of complex field where legislators are rushing into it with this new legislation, and Ofcom will then have to have all this responsibility, create all these duties, and I wish them well in trying to sort out the complexity that is the online space. Graham, did you want to come in here?
Yeah, I think we probably need to separate two different things here. I mean, free speech advocates can quite legitimately differ over where a line should be drawn, in terms of, you will have people who think anything should go, people who think, well, actually it should be, it should be incitement. There are people who would go further than that. But the one thing I'd hope everyone should have in common is that we should know where the line is. And people may think the line is drawn too loosely or too tightly, but you need to know where the line is. And that's a fundamental rule of law issue. Over the years, challenges to free speech, to laws in, for instance, in America, First Amendment, have as often been successful, not on the basis that something is too restrictive, but it's too unclear. You don't know where the line is, and so it has a chilling effect, and you don't know how to, if you don't know what you're going to say is the right or wrong side of the line, you're not going to say it. So the question the more important question of this draft bill is, does this draw a clear line, and who's drawing it? And I think the issue with rather amorphous concepts such as psychological harm is that they move into subjectivity. It was worse, to be honest, in the original white paper. I mean, that had no definition of harm whatsoever. And there are aspects of the draft bill where it seems actually the psychological harm limitation doesn't even apply at all. Whether that's the government's political intention, I'm not sure, but that's how it's drafted. So, but if one assumes that it means psychological harm, then if it's if there's subjectivity there, and if platforms are supposed to be guessing as to whether there's somebody out there who might have suffer a risk of psychological harm, does it have to be a lot of people or just one person? You are creating a very amorphous standard. And if you combine that with the contradictory duties here, what you are ultimately doing is turning Ofcom into a lawmaker. And that is a democratic issue. If anyone should be deciding, even if it's drawing a line that you don't agree with, should it be, is that something that Ofcom should be doing by basically deciding how to reconcile these irreconcilable duties, and so effectively creating a parallel set of laws for online? Or is it something that Parliament should be discussing and deciding, point by point on, for different kinds of activity? Well, this is where the line should be drawn for this kind of for this kind of behaviour.
Yeah, I think one aspect I find quite concerning is this idea that effectively the legislation requires people who have the best of intentions. So people in Ofcom who have the best of intentions, the Secretary of State who has the best of intentions, and we might very well trust the current leadership of Ofcom, the current Secretary of State. But I think when Parliament's designing legislation, or ministers are writing legislation that they hope Parliament will pass, I think it's important to always think about who could potentially hold their roles in future, and the kind of ways that somebody else who you might not necessarily be in your political camp might use the powers that you're creating at a regulatory level, at a Secretary of State level, because the Secretary of State has quite a lot of power to effectively direct Ofcom in terms of the content in its duties or what issues the Ofcom focuses on. Even if the Secretary of State isn't writing the kinds of conduct, they're certainly influencing very strongly their creation. And thinking about how once you set such broad definitions, it creates near unlimited kind of executive power. Now, Victoria, an issue we haven't touched on as much, but considering your role as kind of a regulatory analyst, sorry, I should say, I'm kind of interested in terms of the respective burdens created by this legislation on companies' different sides. There've been a lot of the conversation tends to be around big tech, around Facebook and Google and YouTube and all these large services that are worth a lot of money and have a lot of ability to comply with regulations. I wonder what impact you think this could have on the overall kind of digital marketplace.
Yeah, so what DCMS and the government has been quite keen to emphasise all along is that this is a risk-based process, and it's intended to apply most heavily to the biggest platforms who have the most users and therefore are perceived to potentially present the greatest risk to their users, and accordingly, of course, also have the greatest revenues and therefore the greatest revenue to spend what they're talking about, 1.8 billion pounds in moderation costs, which I gather some people who've looked in more detail at that impact assessment think that's a pretty conservative estimate of the costs. And I think that's probably just over the first 5 years. Now, you might argue, well, okay, but Facebook can afford this and, it's small change for them. They've already got a huge legal department and teams of moderators and AI solutions. But of course, the other criticism that people have in the field of digital policy is that the market is dominated by these particular giants like Facebook, Google, Amazon, Apple. And I'm afraid that there is a great danger that measures like this will actually entrench their positions, simply exactly because they have the deep pockets to be able to invest in the algorithms and the people and the legal advice in order to keep meeting these duties. And it will be much more difficult for startups and scale-ups to keep on investing and keeping pace, because all of these risk assessments that you have to do, you have to repeat them every time you make a material change to your underlying technology. Well, if you're a startup or a scale-up, that's a serious deterrent to actually making your product better over time, because every time you do make a change to it, you have to update all of your risk assessments and keep Ofcom informed and all the rest of it. And the idea of splitting out them into categories based on size. So the most strongest intensive duties will apply only to these so-called category 1 services is also, in a sense as well, a bit anti-innovation, because that actually ends up working as a deterrent to growth. Because if you do eventually hit that threshold, although we don't know what it is yet, by growing your user base sufficiently, you're going to be hit with all of these extra duties and costs. So it's actually a pretty clear disincentive towards growth, and towards therefore actually starting to build more competitors to the existing category 1 services. So I think, aside from the immediate costs that have been reflected in the impact assessment, there's going to be potentially much greater
competition costs,
dynamic costs in terms of competition and innovation.
Yeah, I think it as simply as if you're a venture capitalist and you're thinking of trying to invest in a company that wants to compete with Facebook or Twitter or YouTube, and you want to create some more competition online, you're going to consider the regulatory space and say, well, I don't want to go anywhere near that monster. I don't want to put any money into a company that's going to have to deal with all these burdens, especially considering the fact that these bigger companies didn't have to deal with the burdens when they were expanding and developing over time, and they've gone to scale, and now it's kind of effectively more regulation pulls up the drawbridge, and it completely contradicts the government's agenda from the CMA when it comes to digital markets and competition.
Exactly. And also, a sort of interest group that we haven't really mentioned so far is the consumer, and the consumer's interest in having a plurality of services all competing with each other and doing things differently. And yes, potentially having a service that includes more offensive material that you can use or not use as you wish. But there is a big risk here because of the extraterritorial effect, as we saw with the GDPR, that platforms based elsewhere in the world will geo-block access to UK users. And so therefore UK consumers could end up being deprived of some services where it's just not worth the provider taking their risk in the UK market.
We've got a few interesting comments or questions. William Hyman says, thank you, define malicious content. I'm a carnivore. I don't want to see food in vegetable form. You are harming me. Now what? An anonymous attendee says, will Ofcom need to employ an army of therapists to establish psychological harm to people? I feel that looking at skinny models in Vogue causes harm to our anonymous attendee. Graham, I'm interested on your take about some of the particular burdens that are put when it comes to children. So my way of reading legislation as currently written is that effectively, but let's take YouTube as an example here, YouTube would be required to effectively show by default any users just YouTube Kids, because that is content that's appropriate to children, and that any more advanced content that's not just kind of cartoons on a kids channel, you would have to verify that the user is of a reasonable enough age to access the material. And in order to verify, you're going to have to do something like a kind of quite serious age verification. So something like you have to enter your passport or driver's license or a credit card. Do you see a lot of websites kind of in terms of, in order to fulfill their duty to protect children, having to really separate the internet between kind of, or websites like a child-friendly one by default, and then you'll be constantly having to identify yourself as an adult in order to access not adult content in the kind of pornographic sense, but just kind of generally any content that you might not want a child to see, very broadly speaking?
The whole age side of this is really, really difficult. Partly because, of course, it overlaps with other age verification, age assurance type initiatives. We have the Information Commissioner's Code going on in parallel, and we have the one of the assessments you have to do under this draft bill is to look at whether it's likely that children will access your service, and then if it is, you then have to go through the risk assessments, and depending on what the regulator says, you may be into age verification, you may be into age assurance. I mean, it's one of the real quagmires as to exactly how you. I mean, it doesn't. It it won't make you have two services if you decide, well, I'm going to just have at least I don't think it will, if I'm going to take necessary and proportionate steps to ensure that children can't access my service, then I can go on, I think Victoria will tell me if I'm wrong, without having to do two separate services. But the age verification and assurance are a huge minefield, as we know from the attempt to introduce age verification with the Digital Economy Act, which founded, and it's not going to get any better with this. But what I think you can say is that what providers will have to do will ultimately be driven by what Ofcom says they have to do. No, Victoria, do you have anything to add on that? I think you've probably looked at the age verification stuff on this more closely than I have.
I think that's right, and it is, as you mentioned, very redolent of the age-appropriate design code. The interesting thing as well, which I commented on in connection with the age-appropriate design code, is that if a provider is required not just to verify people, which entails getting their ID, which is obviously an issue for adults who want to be verified so they can access the adult content. So there is a privacy issue there, which of course was a quite well discussed problem with the porn laws, as they were called. But also for the child appropriate content, it's not just supposed to be generically appropriate for children. It's supposed to be risk assessed and appropriate for children of the various ages and levels that they might be, appropriate for, which to me, that entails profiling children, which is again, very counterproductive for what you're actually setting out to do, which is to protect children's privacy in the case of the age appropriate design code, and also, protect their safety here. So if you're saying on the one hand, you have to protect children's privacy and protect them from it being, intrusive users of platforms, but also you have to profile them so you can make sure you're doing so. I think that's another interesting tension at work there.
Yeah, another one of the tensions there, of course, is that, well, two parts. One, you have to pay due regard to the characteristics of the child or an adult. And of course, the characteristics of each child are very different in terms of, when you think of this from an intersectional position, what might be appropriate content, as well as different ages. I think a 16-year-old is very different to what you might want an 8-year-old to view. And I think it's very difficult to figure out. Ruth, just bring you back in. Of course, the Index on Censorship is a global kind of focused organization when it comes to free speech. I was wondering if you want to comment on some of what you think the kind of precedents this could set in the international space for freedom of expression.
So I have concerns in two different spheres, really. The first of which is the issue of anonymous accounts. So if as we're seeing, and we definitely will see this even as amendments require, as amendments to the legislation in Parliament, would be to ban anonymous accounts going forward. Now, if you are a child, or if you are a citizen journalist in Myanmar or Belarus, as we've seen in the last few days, it is for your own personal safety that you operate as an anonymous account. Are we really saying that we're going to stop that kind of journalism? The other thing, and I think just as concerning, is this is really restrictive and empowers people to censor, whether it's, there is a conversation to be had about what is misinformation, what is disinformation, especially during a pandemic or during an election. There are genuine conversations that we should be having about language. But if we're putting down such regressive legislation, then other authoritarian leaders would happily point at us as an example of why they get to do it. And it comes back to your point, Matthew, about the best of intentions. We may well have the best of intentions with the current Secretary of State, but the same language applied by Bolsonaro, applied by Lukashenko, this would have a very, very, very different impact on their street and on their communities, and we would have empowered them to do so. How would we as a government be able to criticise censorship, online censorship abroad, if we are the ones that drafted the legislation that empowered it, and it was just replicated and applied differently, and probably with a much more, well, it would be with a much more authoritarian bent, but it would be the same, potentially the same language as ours. Now, where would that leave us?
And there's of course historic precedent, or recent precedent, I should say, with Germany's net GZ law, which mandated the taking down of hate speech within 24 hours. That a similar approach was subsequently taken by totalitarian countries to require removal of content that we would consider in a democracy to be perfectly reasonable political speech. Unfortunately, we've come to conclusion of our time. I feel like we could go on for many more hours. I think we will keep on discussing these issues for quite a long time as the bill's coming up, and it'll be worth getting the band back together again in future. So, but thank you very much, Victoria Hewson from the IEA, Graham Smith, our friend internet lawyer, and Ruth Smith from the Index on Censorship. Our next webinar, again at 6 p.m. next Tuesday, will be hosted by my excellent colleague Morgan Schonnemeyer. It's about the changing tax consensus. Morgan will be joined by Steve Baker MP, the Conservative MP and member of the Treasury Select Committee, Polly McKenzie from Demos, who's the Chief Executive of Demos, as well as Richard Tether, who's the owner of Tax Strategy Consultancy and a senior tax specialist and lawyer. On that note, thank you very much, everyone, and have a wonderful week.